Hello, everyone. Welcome to the last panel of the day, at least in La Cave. I'm Sophie Stella-Bourdillon. I am a professor in IT law at the University of Southampton, and I also work in industry for a data governance platform which is called Immuta, and which happened to be actually founded in the US. So we are going to talk about shiny technology and technology platforms, digital platforms, smartphone platforms, online platforms are now penetrating almost all aspects of our lives. After having built immense walled gardens without treating privacy as a core design value, they are now making or forced to make bolder privacy claims and implementing privacy engineering technologies in different settings. By way of example, Google and Apple have been developing local differentially private techniques for services such as web browsing and maps, and Google has trialed federated learning techniques to reduce the processing of behavioral data for marketing purposes before making its solution evolved and transform it into a topic API. Google and Apple, as you know, have also partnered to create an exposure notification system in service of privacy-preserving contact tracing. Apple launched in 2021 its permission-based system for targeted advertising, app tracking transparency, making cross-app tracking an opt-in solution only. So the question we'll be asking is whether these platforms are really becoming privacy champions. And there is not exactly consensus on the matter. In this panel, the Computer Law and Security Review will bring together lawyers, computer scientists, and regulators to discuss the benefits and limits of a value-by-design approach and the way this is being implemented by digital platforms. So we are going to ask questions such as, are digital platforms at the forefront of privacy innovation? What do these pets really achieve? And how do or could digital platforms use these pets to strengthen their market position and information power? And finally, what is the role of a supervisory authority in this context? And to answer these questions, we have with us today Joris van Hoboken, who is professor at Free University Brussels and has published with CLSR a paper on smartphone platforms, which happened to actually have won the award from the FPF award this year. We also have Inge Graf, who is an associate professor of competition law at Tilburg University. Remotely, we also have the pleasure to have Mehwish Ansari, who is head of digital at Article 19 and has been working on online platforms for quite some time. We also have Martin Bierry, who is a privacy technologist at the CNIL, running the Digital Innovation Lab, and Olivier Blasi, who is professor in computer science at l'École Polytechnique. So a great panel. Before I start to ask some initial questions, just to set the context, I'd like to remind a few arguments put forward by some of the platforms, and in particular in the context, for example, of the Epic Games versus Apple saga, in which it is made clear by Apple that what they are doing with the Epic Store would be to try to, the ultimate goal is to try to preserve security and privacy. So this is why they are not allowing them to create a new payment system outside of the App Store. I'm sure you've seen this ad somewhere where it is explicitly said that privacy is the iPhone. Yeah, I'm not going to play that. Underlying this, there is obviously a battle between the big techs, Apple versus Facebook, in which Facebook is trying to convince others about the real rationale behind Apple's move, which is not necessarily to protect privacy. At least this is what they claim. And it's also quite interesting to look at some leaked documents in particular the documents actually written by the privacy technologists at Facebook, in which they explain the very intimate relationship between privacy and competition. It's all about controlling data flows in and out. Okay, so let's start the discussion, and I'm going to start with Joris to set the scene and explain the concepts. Joris, can you explain what it means to have platform act as privacy regulators? And what is a privacy governance function? And if you can give us some examples of exercise of privacy regulatory power, that would be much welcome.
Of course, thank you. And thank you for having me on the panel. And so I want maybe just first a step back, you know, like the way that data protection law deals with responsibility is through the controllership concept. And that, I think, is quite relevant also for this panel overall. The thing is that controllership concept is not necessarily kind of conceived or written for like a networked information system, cloud environment, microservices, kind of communicating data with each other. And that's one of the things that we're running into. What we have nowadays is a lot of platforms, but in this context, like speaking of like about the topic that I did a bunch of research together with Ronan Fay, my colleague at the University of Amsterdam, the smartphone ecosystems is a better term, you know, because it's actually like, it's a combination of a bunch of different services, and primarily like the control over privacy is exercised through a combination of the App Store and the control over the operating system. And so data protection law doesn't really necessarily have like an explicit answer to that type of role. And so what you see is that these companies are developing their own, you know, policies on, you know, how to protect privacy through technical standards, you know, in particular like the permission architecture and the way that functions, contractual standards on apps that want to be distributed through the app stores, you know, and it could, for instance, be contractual standards that you're not allowed to ask more data than you need for the functionality that you're offering with your app. And a third function, I think, which is important that connects to both is like also enforcement, you know, how you're actually enforcing those standards, both like the technical standards and the contractual standards. In the article that we wrote, which is called Smartphone Platforms as Privacy Regulators, we distinguish a few more higher level privacy regulatory functions. One of them, organizing for trust of end users, translating regulatory requirements like more local regulatory requirements into a more international context, which of course, you know, like that is super valuable also for apps offering their services, is the platforms are basically help to translate some of the regulatory requirements to like a higher kind of internationally operating ecosystem level. Ultimately, doing a bunch of balancing, you know, between data-driven business opportunities on the one hand and, you know, collecting and using a whole bunch of data of end users on the other hand for the apps. And also finally, you know, and which I think is extremely relevant, actually also playing an important role in, you know, whole discussions about like how privacy should be protected in that ecosystem, because these, like the platforms or the ecosystem providers, they're the ones that have like all this exclusive information about what is actually happening in their ecosystem. I'm not saying nobody else has information about that, but they're sitting on a bunch of like rather exclusive, you know, information about things that are happening. So that's kind of like the starting point. So you can kind of discuss and debate whether it's a proper thing to call, you know, like private entities regulators, you know, but I think considering, I mean, de facto, you know, they are like a primary kind of regulator. They're also for the apps. You see a bunch of literature that for the apps, like the kind of one of the primary disciplining forces for apps is like, what do the app stores and what do the ecosystems allow? You know, like, so they have that de facto function. That doesn't, of course, mean that, you know, they are a public regulator, but it's exactly the fact that these private kind of ecosystem providers become so important for, you know, enforcing privacy in these massive and complex ecosystems that we thought deserves attention.
Thank Thank you. Following on that, so as lawyers, we like new laws because we have something to study and then discuss, but how should privacy law and policy respond to the rise of platforms acting as privacy regulators?
Yeah, there's a few different things you could say to that. Like, so the project we did was primarily about transparency requirements, and we looked at that in a transatlantic context. So, and then actually when you look, so transparency is a legal requirement in privacy law, transparency about the collection and use of personal data. So the question becomes, what are these ecosystem providers doing with respect to transparency? How are they organizing for that? And what, like, kind of requirements they put on the apps in their ecosystem? You know, but there's, of course, a lot more going on from a privacy law perspective. Like, what we ended up saying is that we have not enough information about what these ecosystem providers are actually doing. You know, like, so we proposed to have, like, some basic disclosures about what are they actually doing in terms of the technical standards, their contractual standards, and their enforcement of those kinds of standards. You know, and then, you know, you end up with something that is a little bit similar that you find in the DSA context, and you could actually discuss whether these platforms are actually, part of the platforms are actually covered by the DSA. It's definitely not the primary target, I think, of the DSA, but some discussion to be had. And we think that is very valuable, but overall, I think it's a much more complicated question, and obviously also it's a question of how to enforce basic data protection rules with respect to those platforms. And with respect to that, I would signal that we wrote the article. There was an ongoing discussion about, like, who is exactly a controller and a joint controller. And we know, I think people that have followed, we know that the interpretation of the Court of Justice in Luxembourg is being rather expensive, you know, of that kind of joint controllership possibility. With a new decision, like the Belgium DPA decision in the transparency and consent framework, I would say that there's actually quite a bit of possibility also to push more for enforcement of privacy laws with respect to these ecosystems as well. But with all of that, I mean, it's also the question is, like, what you're really, of course, trying to achieve with that.
Okay, so very quickly, so you are calling for disclosure requirements. I'm going to ask a very naive question, but don't we know enough to use a stronger stick?
Well, I think, like, so quite some of the examples, I think I had this thing written down as, like, so I can imagine from an industry perspective, you know, like, there was this kind of Valhalla land where, like, people would imagine maybe 10 years ago there would be competition for privacy. You know, like, maybe now we're seeing a little bit of that, and now it's still not good, you know, like, but, you know, like, I think the competition, it says already quite a bit. In quite a lot of these examples that you see, it's a competition law issue, you know, and of course we also have just the DMA that got passed, and there's a whole bunch of new things that are relevant for these ecosystems in that context. I think overall also there are quite some cases where you can say, yeah, we can imagine just enforcement of existing law would help quite a bit, you know, like, and can make a difference. So I do think, you know, like, sure, like, we can already do a lot, but the proposal we made about the disclosure requirement is really to tackle the information asymmetries, which are quite enormous. You know, like, so it is a very complex ecosystem, and there's a lot happening, you know. Partly also, of course, because the companies are innovating and iterating on their policies, and they're also iterating on the way that they're policing it. You know, like, so it's really about making sure there is all sorts of policy-relevant information available to policymakers and experts that are following this.
Okay. Well, this is handy because we have Inge next to Joris, who is an expert in competition law. Inge, can you explain us what does it mean to say that platforms, including mobile platforms, use a privacy governance function in an anti-competitive way?
Yeah, thank you, and thank you for having me on the panel today. I think when you look at this from a competition law perspective, there is one issue really at the core of this problem, and that is, I think, how diverging standards are applied. So companies sometimes are very strict when it comes to open up their platforms to third parties, but then don't apply the same standard when it comes to exchanging their data within their own services. So one example of this would be the Google Privacy Sandbox. That is an issue that the UK Competition and Markets Authority is also looking into, where Google updated its technologies. It removed third-party cookies, which is, we could argue, a good thing for users. It protects our privacy better. But that also means that it's more difficult for third parties to track users across devices. And Google itself does not really impose the same standards when you look at how it deals with data across the services that itself provides. So Google, of course, has a whole portfolio of services. And despite the data purpose limitation principle in the GDPR, it still, to a large extent, exchanges that data across services. So this means that you have a mismatch between how companies deal with privacy internally versus how they deal with privacy and the use of data externally. And this then indeed can be something that is also becoming relevant for competition. So there, I think you also see how competition and data protection law can really strengthen each other. Enforcing purpose limitation could help competition. So on a panel earlier today, this was also discussed, and a lot of responsibility was shifted to competition authorities like DG Comp, Wake Up, help us enforce purpose limitation. But I also think that, of course, GDPR already has purpose limitation in its provisions. So there is also a role for data protection authorities to enforce this and help make markets more competitive. On the other hand, of course, there's also things that competition authorities could do. One example that I could point to is Google Fitbit, where the Commission imposed a data silo, where where Google is not allowed to use the Fitbit data for targeted advertising. So we can discuss whether this remedy is effective in itself, but this is again an example where you see that the use of data can lead to remedies both in competition and in data protection law that I think can really complement each other. And this goes back to this core phenomenon that we see that companies, when they have market power, they have a lot of ability to gather data and use this data to also enter connected markets. So this leads to what we would call in competition terminology market tipping. And if there is no stop put to it by whatever regime works best in particular circumstances, this can indeed also lead to privacy problems and give those companies really a huge data advantage.
I mean, do you want to add anything about how should competition law and policy respond to the rise of platforms as privacy regulators, just to complement what Joris has been saying already?
Yeah, so Joris said, well, I'm not sure if it's right terminology to say that these platforms are becoming privacy regulators. In fact, this is terminology used in the competition policy setting. There was a report from 2019 where Competition Commissioner Vestager asked 3 experts, 1 lawyer, 1 economist, and 1 data scientist to advise her on how we could update competition policy for the digital era. And they indeed also refer to this phenomenon that platforms start to act as regulators, so setting up the rules and institutions through which users interact with each other. And actually, it's interesting to see that they make an analogy with something else that already exists. And we often think that some of these things that we see in digital markets are completely new. But in fact, we could learn from how this has been dealt with before. And one analogy they make is an analogy with sporting associations. So there has been a case, the ISU case, about the International Skating Union, where 2 Dutch professional speed skaters complained to the European Commission about the rules that ISU imposed on them. And ISU is a sporting body that indeed sets out the rules for the competitions that speed skaters can engage in. And these speed skaters wanted to participate in a competition that was not on the official list of ISU, and ISU banned them from competing. And if they would still compete, they would be banned from being part of the official speed skating schedule. So they went to the commission, complained that this is a competition problem, and indeed this went all the way up also to the EU courts, where also it's interesting to see that the General Court refers to the ISU as having a regulatory function. So this is indeed already something that is recognized in competition enforcement, in competition law, where the court also says in this case it was really disproportionate for the ISU to put such a ban on these speed skaters. Then one other analogy to complete the answer that I can think of is in the context of objective justifications in competition law. So there has been a case earlier on, a few decades ago, on tying. So tying means you sell one product, and if you buy that product, you also have to buy another product that is tied to the original product. And there was a case, Hilti, a producer of nail guns for the construction sector, and Hilti said, well, if you buy our nail guns, you also have to buy our own nails because of safety reasons. We don't want you to use any other nails because then we can't predict what will happen. So because of safety reasons, we are going to tie those products together. And here again, both the European Commission and the court said that this is not for a dominant company to decide. We have authorities in charge of safety regulations, and these should be the ones that determine what should be the standard in the market, not the dominant company. So a similar type of thinking you could also apply to this privacy setting.
Okay, and looking very briefly at the regulatory landscape, are you welcoming the Digital Services Act package? Is this going to change anything?
I think it's definitely a welcome addition. I think a lot depends obviously on enforcement. There is some additional obligations that will apply, particular in the Digital Markets Act when we talk about really powerful gatekeeping platforms, also when it comes to how they use their data. One provision there is that gatekeepers are only allowed to combine personal data across services, to combine data generally across services when they have the consent of the user to do so. There I would have welcomed a stronger safeguard, because I think in this way we still leave a lot of responsibility on the individual user to decide whether or not he or she is going to let her personal data be combined or not, while this also will have collective impact on others and also on the market as a whole. So one trade-off that I see coming up in these debates is between protecting the individual interest and the collective interest, where we might, in certain cases, want to give a bit less leeway and a bit less space for individual empowerment and ban certain choices when we know that combining a lot of data, for instance, will lead to more concentrated markets to the detriment of choice, innovation, competition. So I think there is even challenges beyond what these new legislations try to address, where I think our community and the competition community as well should be thinking about towards the future as well.
Okay, thank you, Inge. Going to Maywish now, hoping that you can hear me, and hoping that you can bring into the discussion the NGO perspective. Generally speaking, what should we think of platform privacy activism? What would you say from your perspective? Can we assess today whether the role platforms are playing as privacy regulator is sufficient? I take it that the answer is no. Yeah. How should regulators and lawmakers respond, therefore, to the rise of platforms as privacy regulators? Okay, and quickly, so Joris mentioned the DSA, saying that maybe we can use that framework to try to tame the platforms. Could we use the DSA as a model, the Digital Services Act, as a model to regulate these privacy regulators? Okay, that's okay. Thank you. Thank you for setting the scene here. Now we are going to enter the more technical space of pets. More technical, obviously, because I am the lawyer. I am not the computer scientist. And I'd like to bring into the discussion Martin, who is going to enlighten us about platforms' use of pets or privacy-enhancing technologies. One argument why platforms have been described as privacy champions is because they are the ones using the infamous pets. Obviously, they've got the resources, so that might be one obvious reason why they are using these pets. Martin, to what extent have platforms led privacy developments, in particular in the pet space? And if you could give us some examples, that would be fantastic.
Hi. First of all, maybe I can make a little observation. There was a major shift in the discourses of the digital platforms. Not so. Can you hear me? Not so long ago, maybe 10 to 15 years, some executives and CEOs from Silicon Valley were saying stuff like privacy is an obsolete concept, or privacy is not existing anymore. So I'm glad we came back from that, because we know it's not true. I mean, privacy has changed for sure, but I mean it's a new balance. We choose what we want to show online, and what we don't want to show, and that we don't want to be seen. And what we don't want to be seen represents still a lot. So, I mean, it's good to stress that privacy is still a valid concept nowadays, and I'm glad the digital platforms have understood it. And maybe I'm not being objective here, but I think regulation like GDPR help them to some degree to embrace data protection and protection of privacy. That being said, we can acknowledge that these digital platforms have the firepower to develop and to implement advanced technologies, and in order to empower the individuals and to empower them to control their digital environment and their digital devices. And there is some example in the past, like, I mean, the do not track is a good evolution. I mean, Safari, Firefox, and this kind of browsers have implemented it and have provides individuals a way to say no, maybe easily. We can see also an evolution in the OS, like Google and Apple. They have evolved regarding permissions that apps have regarding collecting the data. And maybe a good example is a recent one. Google have announced that they have rolled out a new privacy section in the Play Store. There will be a new privacy labels. That means apps have the obligation now, I guess it's until July, to explain what data they collect, how they use it, with the link to their privacy policy. So we can see it getting better and better. These labels will be also linked to the respect of restriction rules about advertisement for children and data protection. So that's a good evolution. I mean, it's not hard bets, but it's building differently the architecture of the stores, and it's a step. Maybe what would be interesting is to see how Apple and Google will follow their own rules. They ask for the apps and the services that use their stores.
Okay, and just very quickly, so not all pets are equal. What do they achieve in terms of data protection?
I mean, they can achieve a lot. It can be transparency, it can be information, and if we talk about hard pets, I mean, advanced technologies, with the right implementation, it can do a lot of things. I mean, we are talking about encryption, decentralized way of processing data. I mean, stronger encryption is a good illustration here. Even if the data is leaked, if it's encrypted the right way, and if the keys are safe somewhere else, then we can assume that the harm is less intense than if it wasn't. And there is a lot of new technology that are becoming more and more mature right now. I mean, we can if we look at major principle of the GDPR, like minimization of data. For instance, zero knowledge proof. With this technology, you can share just what is needed. I mean, you can prove mathematically that a proposition is true without sharing anything else. And if you have any question on this, Olivier is the expert, so I won't say more. But there is more and more advanced technologies like anonymization. I mean, like differential privacy is a new way to protect the identity of an individual in a data set by reducing the risk of re-identification, retro-engineering. So it's adding noise to a data set in a way that you can protect the individual. And there is, I can go on with federated learning. It's also a good way of protecting privacy. The concept, it's simple. You don't have a centralized data set. It's all decentralized. And if we take an example, if you're using it via an app or a smartphone, it means that the model will function on the smartphone and then send the parameters to a central entity that will get all the feedback from all the smartphones that are using the models, and then doing iteration and send back a new model improved with these feedbacks. So that means there is no centralized data set. And just maybe a quick word. With this kind of solution, it's not just a software you put on a computer and that's it. I mean, it's architecture, it's governance, it's processor, and it requires time and it's tools. So we don't want to fall into technological solutionism, just saying that the technology will solve everything. That's not true, and we have to keep that in mind.
Okay, and if I ask another very naive question, assuming you can answer, can pets or other privacy-preserving practices become anti-competitive?
Yes, I mean, data collection is a barrier for new entrants who are not able to gather the same type and quality of data. So yeah, around the data there is a competition, a lot of competition issue actually. It can also lead to violation of consumer protection. But like I said before, pets are tools, and it depends how they are used and how. If it's a way to reinforce the gatekeeping or the gatekeeper position, yes, they would be. But if they are implemented in the right way, without removing the possibility of data sharing or access to the data, I mean, they could also help this kind of process. You can share more easily a data set if it's anonymized with synthetic data or differential privacy. So it really depends of the use you add with them. And yeah, that's it.
Okay, thank you. Turning to the expert of pets, Olivier, I'm just trying to unpack further the concept. So Martin mentioned difference between hard and soft pets. Can you explain in your own words what are pets and what's the difference between a hard and a soft pet?
Okay, so hi everybody. So pets are privacy enhancing technologies. So that's every technical solution that you can use to increase or protect privacy of your users' some data. So in that, you have suspects. That's basic encryption or differential privacy, where you need some level of trust in the person applying the PET. So either because it's an authority, it's a data collector, and you want to trust the data collector to indeed encrypt and store the key securely in another place, or to properly anonymize or add some noise to the data. And then you have hard PETs that are technologically stronger and harder, where you remove this trust. So depending on who you are, either you remove the trust or you put it somewhere else in another party that is completely independent and normally incorruptible. And for this, you're going to have end-to-end encryption, onion routing like in Tor or Mixnet, and somewhat locally differential privacy. So, this is a very different paradigm because in soft PETs, it's quite easy to make them accept by platform because they are still getting the data at the end. They have to secure it, but they have the data and they can do more or less whatever they want, at least technically they can do whatever they want with it. And in the other case, the data is already transformed and pre-processed in a way that is supposed to fit the finality of the collection and nothing else. So this is a hard difference between the two of them. But what should be thought when you use PETs, it's not a magic solution. It's not a black box that now I have data, I'm going to use, let's say, fully homomorphic encryption, and it's going to be perfectly secure. Because first, you need to implement it correctly, and the finality, the function that you want to evaluate is also important. I mean, if you evaluate where I'm located right now, at the end, it's going to tell you that I'm in Brussels, and that's already sensitive information. So it's not because that you did a secure computation on the data that the data is still not relevant at the end and not leaking private information.
Okay, so looking at the PET space, I mean, is it true to say that platforms have been leading in that space? How many of these space are they really using?
So it depends. I mean, if you look at soft PETs, platform, most of them are using SSL/TLS. So in one way, they are already using PETs because they are using encryption and authentication when you are communicating with them. Then it's to say that at the very beginning, Google and Apple are using some kind of differential privacy for some systems. So either for tracking what we do in the browser, or Apple, for example, has one for tracking emojis that we use. So they are trying stuff and they are using some PETs to protect some part of user privacy. The part that saddened me in this is that I'm a cryptographer, not a data analyst, and they are mostly using differential privacy and not really advanced crypto to do this. And so it's the data is going to be private according to a model, and if you fit the profile, and I'm always interested in what happens in the exception, and if you are not really a typical user, what happens, and are you really protected in this case? And there are many other PETs, so there is end-to-end encryption, but there are also concepts like zero knowledge or fully homomorphic encryption. And in fact, okay, big platforms are trying to use it, but they always say that it's too costly and it doesn't scale. And if you look at other companies, you see many companies, mostly in Europe or not really on the US side, that are in fact getting involved in this concept and that are showing that, okay, doing fully homomorphic encryption for any kind of function is quite complicated. It's getting somewhat efficient. But in fact, most of the time you are going to do mean, computing average or value or small degree polynomial evaluation. And that's in fact very easy to do. In fact, it's mostly doable with current technologies and it's really efficient. So platforms are leading PETs, in fact, in the ways that they want, so trying to orient to differential privacy and getting rid of the crypto concept behind it. And in fact, you can see many opponents or small companies that are in fact doing the exact opposite and taking privacy back and proposing the hard PETs in a usable, nearly friendly way for other companies to use.
Okay, and last question, so they are called PETs, privacy enhancing technologies. They were intended to protect privacy, but PETs can also be used to protect confidential information, so commercially sensitive information. At least this is what I have been told. So can you say a few words about that? So they can. I mean,
I'm going to start with the crypto. If you look at crypto, you don't care about what kind of data you're using. It's just data, and the data is going to be protected, be it about a user, about a bank account, or whatever. So you can use end-to-end messaging, for example, to do a secure banking transaction, and there has been many use in this case. If you look at differential privacy, it's a little more complicated because you need to know what kind of data you are processing just to be able to properly mask it or add noise. And it's doable, and you will find application in this case, but it's in fact less easy to have used the RPET at the beginning, because in RPET you are completely, the kind of data you are processing is completely irrelevant.
Okay, so as usual, technology is, well, some would say neutral or ambiguous. I mean, it all depends on how you use it and for which purposes you want to implement it. Thank you so much. Before I give the floor to the audience and I invite them to ask questions, do I have any member of the panel who wants to respond? Or add something to what has been said already?
No, it's been super interesting to hear all the contributions. I think I wanted to say one thing about this innovation question and the paths, So, when you look at, the landscape where the real privacy innovation is happening, it seems quite obvious to me that like some of the biggest kind of privacy eroding companies are doing the most innovation, like that is just because like you can innovate in privacy, especially in the kind of technological sense, to make things that we would otherwise not accept acceptable, and so that's like, it's like you end up having a bunch of security and a lot of transparency. I mean, that's actually what data protection law does. It's like we accept, a whole bunch of collection of personal data as long as you fulfill this and this and this requirement, and you can add a bunch of stuff with technologies, and with that, it works a little bit like communicating vessels, so you do a lot of, do stuff that is quite kind of freaking people out from a privacy perspective. You have to do a lot on the other side. You have to innovate a lot on privacy. And I think we've seen that play out over the last decades, and definitely I think, what Google and Apple are doing in the smartphone ecosystem, it fits pretty well in that space. But I would make another point about the stuff that is happening with pets, because sometimes I think what happens is that we go and talk about pets and we evaluate pets like they're kind of technologies that can help do stuff, functionality, without disclosing information, to parties that you don't necessarily want to trust. Like that is the way I understand it. But so that is great if the privacy issue is actually the sharing of that data. But if the functionality is the issue, then your pets don't solve anything, but it make it mainly how do you say, palpable, like people can kind of like, oh, that's great, like now we can do multi-party computation, and like data brokers can talk seamlessly with like what is happening on Facebook and integrate, and you can understand. I mean, we have all these reasons why we don't like to see certain large databases be combined. You can do that maybe in a very privacy-friendly way, in the sense that you're not sharing any of the data, you're not really combining the data sets. But from a functional perspective, you're actually developing that new type of power that is then also for sale, so. And I think this is a very important thing, to look at these privacy innovations from like really kind of from a first principle perspective. What is actually the issue here, so that, and like maybe then to say, like in response to the third speaker, maybe Ansari, I think that it's some really excellent points he's making about the more infrastructural dimension that is also should be on the table here. So it is quite clear that like what we see with what we saw with COVID, it's an infrastructural play that is happening, like being able for Apple and Google to move into this kind of health domain in a kind of trusted way, and also, getting basically your. I mean, this is not new, but like to have this app infrastructure become like the turn-to infrastructure for developing these kinds of new health policies, that is something, of course, that that's a huge strategic benefit, I think, that has to these companies, and it should get our attention to look at that. And maybe they managed to do that with some really pretty amazing and advanced kind of contact tracing implementations. It's quite amazing the work that was done around this. But ultimately, we then have included these infrastructural players into these kind of health policy domains.
Okay, thank you. Any response from the panel? Maywish, do you want to add something? Okay, thank you. Well, the panelists are yours, so feel free to ask questions.
Michael Veal at UCL. I'd like to ask a question that builds on what Joris had said there. I feel uncomfortable if we were using pets to sort of have your heart rate and eye gaze be used to profile you. And I was wondering if there is a way in pets research to build systems that allow for a plurality of pets, to people to decide the functionality and optimization aims, or if the idea is so baked in that people are people are actually able to opt out of a computation they don't like. Because I think that's what we're seeing here. On a device that you don't really own and can't really audit, you can't just say no to participating in a multi-party computation that has a bad aim, particularly if you use a zero-knowledge proof to condition free compute or free cloud services on actually profiling yourself in the way that is expected, or running the computations as you like. So can pets research really cope with the idea of a plurality of pets? Or does it need to develop in that area? And where does the panel see that in research and practice?
Olivier?
It's going to depend. I mean, technically, I think it's a great idea, and that would be nice to be able to ensure this. But the problem is at which point do you think that the user is going to be able to give consent or remove consent to be able to participate in the pet? Because as you said, you are using a device you don't own with apps that you don't really control. And at some step, maybe when you are going to say, I don't give consent, in fact, you can imagine that the software behind it processes the data anyway and just doesn't tell you. So there's going to be a problem, and you will need at least one bit of trust to be able to derive from the normal processing of the pet. So I think the problem is interesting, and you can try to find a physical solution where you will have a hardware device that you need to plug to another one to be able to launch the processing of the data, let's say. So this way, your consent will be a physical action. And this would be a solution to try to get this consent back and remove the trust, because at least normally physical laws are not going to be broken.
Can I build on that? So if in a multi-key setting for, let's say, homomorphic encryption, for example, is there a way to give back to the user some empowerment and ability to say yes or no?
I mean, the user is always able not to take part in the process. And so if you use so it depends what you call multi-key seeking, but threshold encryption, where you need at least 2 keys out of 3 to be able to process the data. If the user possesses 2 of the keys, either the server is going to be to launch the request and miss 1 key, or the user can launch it. And so in this case, the user can have some part of involvement in the computation and normally make sure that it's not going to happen. But if you don't trust the infrastructure and the implementation behind it, maybe it's not 2 out of 3, but 2 out of 4 keys, and the two keys are on the side of the server, and so at this step you already lost. But at least normally, if there's then control authorities that come and check what is happening, it can ensure that the user has some part of control on the data and the computation.
Okay. More questions?
Thank you. Kasia Szymilewicz, Panopticon Foundation. Listening to the panel, I felt skepticism among all of you about the trend of platforms showing the privacy-friendly face, and I wonder whether it was just my interpretation or indeed you are making this point that we might have a variety of new technologies and tools, but everything that really important stays the same on platforms. Is this the argument you are making? And if so, why is it the case? Is my interpretation correct that big platforms applied privacy-friendly technologies where that didn't threaten their business model? For example, we can have more data on our devices. The data can be encrypted as long as the analytics can be executed exactly in the same way, because there is federated learning and there are more novel ways of doing machine learning. So Google can continue the same business model. Is my intuition correct that the business model is not threatened with these privacy-preserving technologies, or the landscape maybe is more complex and indeed something meaningful has changed through this privacy protection narrative?
It might be that the business model has not been jeopardized, because in some of these cases this is a way to empower the platform to control better the flow of the data. So any reaction from our panelists?
Correct, indeed, that, there is the issue of the double standards that I talked about, that they pretend like they come up with privacy standards, but then it's either in their own interest or in such a way that it will still preserve their business model as much as possible. So I also indeed think we need to have a shift in thinking with stricter regulations. There is some developments coming up, and we will have to see what happens with these new acts. The Digital Services Act has a ban on use of targeted advertising in some areas. The DMA will have stricter obligations on how platforms can use data. And I think one mechanism that we can also think about is, because that is what I often find tricky in these discussions, that platforms and the businesses themselves, of course, know exactly what they want to do, what they can propose to a regulator in a way that is as least burdensome for them. So I also think we need to think about doing regulation in a different way. So the Digital Markets Act is an example where you have this regulatory dialogue, so where there is a list of obligations, the companies have to meet that list of obligations ex ante, and then there is a dialogue with the Commission discussing how exactly this could work. Of course, you will also need to have market players involved to do additional checks. Consumer associations might need to be involved, and I also like a lot this idea of the Digital Services Act that researchers get access to data. So I think we really need to have a mix of strategies where there's various checks and balances in place to really try to shift this thinking.
Yes, you want to answer?
Yeah, so maybe to answer that question. So I don't think, I really don't think anything happened in this space that was not also strategically sensible from the perspective of the companies. I mean, obviously that includes that there are certain expectations of privacy if you're like a service provider like that. You could just basically from a market perspective, people deciding whether they're going to switch between an Apple phone or a Google phone, they take into account, that by now Apple is maybe, or since a while, Apple is doing a little bit more maybe to do So it's that's consumer behavior. And the consumer behavior has there is consumer behavior around privacy and security, and it has incentivized also the companies, of course, to do certain things and like to innovate and to do more and then of course also to ultimately make it possible to make these ecosystems grow and be even more profitable. But that is ultimately, I think, then the goal. I think we can be honest about that. It's like I don't think that there's been put a lot of intrinsic value to privacy that is not also can be explained through strategic motivations by the companies. And, to be honest, I don't think we should expect that, and I think, for the companies, it's clear that they will have to continue innovating to be on top of all the things they're doing, and to be able to have some story that they're doing a good job. And so anything they're doing, it's like, okay, and what's the next thing? I don't think they're ever going to be finished with that. And we should continue to press them also to keep innovating, and we have to think about whether this kind of super by two, I'm talking about the smartphone ecosystem now. It's a very it's a area that's very dominated, of course, by these two companies, and that's by itself a problem. I mean, there's a whole bunch of competition and other types of cases around that, and and the rent-seeking behavior has been mentioned. The types of profits, that are being made, they're enormous, of course. Yeah.
Thank you. Question at the back.
Hi, Kaya Molinska. I'm from Leiden University. I think some of the panelists have already touched upon that, but can you identify whether the current situation, the pets not being quite what we would like them to be, if that's a shortcoming of the legislation we have, or rather an enforcement gap, and if we really need to change that much about our approach, or rather our effectiveness in enacting it?
Some have actually argued that we should, through Article 25, we should make hard pets a hard requirement. Whether that's the fact that we have pets of this type is a consequence of a flawed regulatory framework, I'm not sure. The framework is obviously at a high level. Then it's a matter for the organization to decide which controls they want to put in place, having the different data protection goals in mind and trying to meet all of them, not only one out of 6 or 7. Any reaction from the panelists to that question? Martin, do you want to say anything about hard pets and trying to achieve requirements such as Article 25?
Yeah. Oh, sorry. Yes. I mean, I'm not sure there is a need to an obligation of hard pets in order to respect the legislation, like the GDPR. I mean, the GDPR, its major principles and it's a spirit, and it's already there. I mean, you don't have to wrote down that pets are needed, because with Article 9, Article 25, Article 32, security measures, I mean, it's already something that is being asked by the GDPR. So maybe there is a need for other way to promote this kind of tools. I mean, like guidelines, recommendation. That's the role of DPAs and other administration and institution. But yeah, I mean, I think it's already in the text, and it has to be taken into consideration by the different actors.
Maybe what is missing is a guide to show how these pets should be assessed. So explaining clearly what is it that they achieve, and the counterparts, obviously, of implementing something which are...
Like Olivier said, like TLS and HTTPS are standards now, but they weren't in the past. So art pets and pets, as we mentioned, federated learning and stuff like this is pretty new. So we can't just say you need to go with differential privacy on this. You need to go on federated learning on that. It's mostly case by case, and you have to balance between the purpose and what you try to achieve.
Okay, thank you. I'm being told that we need to close the panel. Thank you so much for being with us this evening, and I hope to see you around soon, tomorrow and the day after.